So imagine a world where settling a property dispute with your neighbor means the two of you literally have to step into a field and, like, fight with broadswords until somebody yields.
Yeah, just completely brutal.
Right, and the winner just gets the land. Or maybe to prove you didn't steal a horse, you have to plunge your bare arm into boiling water and carry a red-hot iron for, like, 9 paces.
And, the craziest part is that wasn't a movie script.
Mm-hmm.
That wasn't some dark fantasy novel. That was the actual functioning legal system in medieval England for a very long time.
It's wild, because when you and I think about the justice system today, right, the courts, the juries, the incredibly dense rules of evidence,
Yeah.
we naturally assume it was all designed by some grand architect.
Yeah.
We picture this room full of brilliant scholars drafting the ultimate blueprint for fairness.
But the reality is so much weirder than that.
Exactly. Our modern concepts of justice were essentially hacked together from the mud of that brutal medieval landscape by a literal traveling band of rogue judges.
It's really one of history's most profound examples of organic bottom-up evolution. I mean, it completely defies the idea that complex functional systems have to be engineered from the top down.
Which is exactly why we're plunging into this today. So, welcome to today's deep dive.
Glad to be here.
We are exploring some incredible excerpts from a book by Young Kang called The Legal Philosophy of the Common Law. And our mission today is to trace how the English common law system actually formed.
Right, because it's not what most people think.
Not at all. And if you are listening to this right now, whether you manage a team, design software, or just want to understand how incredibly complex human systems evolve, this is an absolute masterclass.
It really is.
It's this stunning historical proof that providing a better alternative and letting people voluntarily choose, it almost always beats, like, forcing compliance from the top.
Yeah, and to understand the sheer scale of what was achieved, we really have to drop ourselves into England before the year 1066.
The so-called Dark Ages.
Exactly. And if you were looking for a unified, rational legal system back then, you would be deeply, deeply disturbed by what you found.
Yeah, the text mentions a landscape heavily reliant on kinship ties, oaths, religious ritual. But what does that actually look like for a normal person? Like, if I have a dispute, how does it actually get resolved?
So it was a wildly localized, just fragmented patchwork. Every county, every tribe, every feudal jurisdiction had completely distinct traditions.
Okay.
And they didn't rely on fact-finding at all. Let's take compurgation, or what the text calls oath helping.
Wait, oath helping. Does that mean, like, if I'm accused of a crime and I can just find 12 friends to swear I'm a good guy, I literally win the case?
That is exactly what it means.
You're kidding.
Nope. It wasn't about the evidence of the crime. It was entirely about your social standing and your kinship network.
Wow.
If you could rally enough oath helpers to swear a precise, formalized oath in unison without, stumbling over the words, you were cleared.
That is so arbitrary.
Yeah.
So what if I didn't have 12 powerful friends?
Then you might be subjected to trial by ordeal.
Ah, the red-hot iron.
Exactly. The iron you mentioned, or being thrown into a river to see if you sink or float. The belief was that divine intervention would protect the innocent.
Right.
But in practice, as the text bluntly notes, these procedures were prone to rampant perjury, total irrationality, and incredibly inhumane outcomes. I mean, it was a system built entirely on local power dynamics.
Okay, so that is the baseline. Mud, nepotism, and burning iron.
Pretty much.
Then we hit the year 1066. William the Conqueror, the Duke of Normandy, crosses the Channel and conquers England. The Norman dynasty becomes the first ruling house to achieve truly unified military rule over the entire realm.
And this is a crucial pivot point.
Right, but I actually have to push back on what the text says here, though.
Oh, how so?
Well, the text claims William showed brilliant restraint by not wiping out the local Anglo-Saxon customary law.
Yeah.
But I mean, his title is literally the conqueror. When a foreign invader takes over a country, step one is usually burning the old laws to the ground and forcing everyone to obey the new regime's rules, right? Like, to assert dominance. Why didn't he just mandate Norman law everywhere?
Because William recognized a fundamental truth about power, which is that forced radical eradication breeds endless rebellion. If he had marched into every local village and told the local lords, your courts are abolished, your ancient traditions are illegal, he would have spent the rest of his reign fighting 100 different civil wars.
So it was just practical.
Very. Instead, he overlaid a stable central monarchy at the top, but actively allowed those highly localized, messy courts to keep functioning.
He kept the peace by not micromanaging.
Exactly. And by not destroying the local systems by force, the Norman kings inadvertently provided the fertile soil for a much more subtle revolution later on.
How do you mean?
They created an environment where a better system could eventually outcompete the old ones naturally.
Which brings us to the actual aha moment of the story. It takes like a century to simmer, but we arrive in 1176.
Right.
We have a new king, Henry II, from the Plantagenet dynasty. And Henry realizes he wants more national unity, but he wants to do it through the judiciary, not through military force or like a massive administrative bureaucracy. So he formalizes something called the Assizes, the Royal Itinerant Courts.
And this is the genius of stealthy centralization. Henry dispatched specially trained royal judges to leave London and periodically travel around the counties, exercising judicial authority directly on behalf of the crown.
When I was reading this part, my mind instantly went to modern systems design.
Oh, yeah.
Yeah. Imagine administrative centralization as a CEO forcing everyone in a massive company to use a clunky, brand new corporate software system. What happens?
Everyone hates it.
Right. Middle managers drag their feet, employees hate it, productivity plummets, and there's just constant friction.
Because you are actively stripping away their autonomy.
Exactly. But judicial centralization. That's like the CEO quietly launching a brand new, incredibly efficient IT help desk that is completely optional.
I love that comparison.
Right. You don't have to use it. You can keep using your local guy who takes 3 weeks to fix a printer. But when the new help desk fixes your laptop in 5 minutes with zero hassle, people just start flocking to it voluntarily.
That is a phenomenal analogy. In a political sense, administrative centralization requires the direct, forceful suppression of local nobles, and that provokes armed resistance.
Nobody wants that.
No. But judicial centralization operated under the unassailable banner of providing more just adjudication.
It's like, hey, we aren't taking your power away. We're just offering some really high-quality justice over here if anyone wants to try it.
Right. The local nobles couldn't really complain without sounding like they were actively against justice itself.
Which is brilliant.
Precisely. It bypassed political conflict entirely. The Crown never passed a law saying you must use the traveling judges. They just let the litigants decide.
And this creates one of the most bizarre and fascinating realities in medieval history. You suddenly have all these parallel, overlapping court systems operating at the exact same time.
Yeah, it was a crowded market.
The text lists the county courts, the manorial courts run by feudal lords, borough courts in the cities, ecclesiastical courts run by the church, and now the royal itinerant courts.
All possessing concurrent jurisdiction, meaning for the exact same property dispute, a litigant could literally shop for justice.
Shop for justice. That's so interesting.
Yeah. They could look at their options and choose the forum they thought would give them the best, most reliable result.
It's a true competition among courts. It's not a financial market, but an institutional one. Let's put ourselves in the shoes of a medieval farmer trying to figure this out, because the text breaks down exactly why the royal courts eventually crushed the competition.
Right. Well, the first major advantage a litigant would notice was professionalism.
Okay, imagine I'm this farmer. I need to sue my neighbor over a stolen flock of sheep. If I go to the manorial court, the guy sitting in the judge's chair is the local feudal lord.
And for him, holding court is basically a chore.
Exactly. His real job is managing crops, collecting taxes, or fighting in wars. He has zero formal legal training. But if I wait for the royal judge to ride into town,
that guy is a full-time professional. His entire life is listening to complex cases. He has stable, predictable modes of reasoning.
And that leads directly to the second massive advantage, which is neutrality.
Yes. The itinerant judges were, by definition, travelers. They were outsiders.
Which is everything in a small town.
Oh, absolutely.
If I go to the local lord, what if my neighbor is the lord's cousin? What if my neighbor's family has been paying extra taxes to the lord for 3 generations? I am completely doomed.
And in a medieval society obsessed with lineage and local geographic loyalties, finding an actually neutral third party was almost impossible. The traveling judges from London transcended those local networks of relation. They didn't know the local gossip, they didn't care about the local feuds, and they weren't susceptible to interference from the regional nobility.
Okay, so they are professional and they are neutral. But the third advantage the royal courts offered is probably the most famous.
Trial by jury.
Yes.
This was a total revolution in fact-finding. We discussed the local alternatives, right? The oaths, the boiling water, the judicial duels.
All the chaotic stuff.
Right. Well, for a requisite fee, the royal courts offered something completely different, a jury.
The text notes this was originally a royal privilege, but they opened it up to the public.
Exactly.
Instead of carrying hot iron, a group of your peers actually sits down, examines the physical facts of the dispute, and uses collective, rational deliberation to reach a conclusion.
The contrast in credibility is staggering.
Yeah.
I mean, if your entire livelihood depends on the outcome of a land dispute, do you want to risk it on whether your neighbor is better at sword fighting?
Definitely not.
Or do you want a panel of 12 locals methodically reviewing the property lines? The rational choice is obvious.
And finally, the fourth advantage, enforcement. Because, I mean, it doesn't matter if you win the case if the losing side just ignores the verdict.
Right. Judgments issued by the itinerant courts were rendered in the name of the crown. They carried the coercive physical force of the king.
So if the local lord tells a powerful local family to give me my sheep back, that family might just laugh at him.
Probably would.
But if the king's traveling judge orders it, ignoring that order means you are defying the King of England. The muscle backing up the verdict was entirely different.
Exactly. By simply providing a more professional, neutral, rational, and enforceable remedy, the royal courts naturally marginalized the local courts.
It's like Young Kang writes in the text, institutional superiority emerges through practical competition rather than abstract design.
It's a really powerful concept.
Okay, but I have a major mechanical question here. England is huge. The customs in the north are totally different from the customs in the south.
Very true.
If you have all these different judges traveling to different regions, making decisions on the fly based on local quirks, how does this not just devolve into total chaos?
That's a great question.
Like, how does a single judge applying a weird local custom in one county turn into the common law for the whole country?
That is the crucial missing link, and it all comes down to the feedback loop.
Walk me through that. How do they organize the chaos?
So the itinerant judges didn't just stay out on the road forever. They operated in circuits. They would travel through the realm, acting sort of like legal anthropologists.
Okay.
They encountered these wildly diverse local customs. When they decided cases, they actively compared, selected, and integrated the best parts of those local rules.
So they're doing field research while adjudicating.
Precisely. But the magic happened when the circuit ended. These judges would return to London, specifically gathering in the King's Bench or the Court of Common Pleas.
And what do they do there?
They would sit down together and deliberate. They essentially compared notes, refining the reasoning behind their individual decisions based on what they had all observed across the entire country.
Oh, wow. The text actually uses a beautiful phrase for this mechanism. It calls it the continual cycle of local experience, national exchange, shared principles.
Yes.
They took the raw data of local customs, brought it to the national hub, debated it, and synthesized it into rules that were common to the whole realm.
Which is literally why it's called the common law.
Ah, that makes so much sense.
Right. It wasn't written down in a grand code by a monarch. It was synthesized from the ground up. But to manage this massive flow of information, they had to rely on something called the writ system.
Right. The text emphasizes the writ system heavily. What exactly is a writ?
A writ was a formal written order from the king, essentially granting permission for a specific type of lawsuit to be heard in the royal courts. But it wasn't just a generic permission slip. It was incredibly strict. Different types of disputes, like a broken contract, an assault, a property eviction, they all required highly specific, meticulously worded writs in Latin.
Oh, it's like an API request in software engineering.
Ah, you mean?
Well, if you don't use the exact right syntax, if you leave out a comma, the server just rejects your request entirely. You get an error.
That is exactly how it functioned. If you bought the wrong writ, or if a single word was misspelled, your entire case would be thrown out, regardless of the facts.
Wow.
It was a staggering level of procedural complexity.
But why make it so complicated? Didn't that just slow things down?
It did, but it also created an unintended consequence that changed history. Because the writ system was so complex, the average person, and even the average noble, couldn't navigate it.
Right, you'd need an expert.
Exactly. This directly fostered the growth of a hyper-specialized professional class. You suddenly needed professional judges and a distinct, highly educated class of lawyers whose sole job was to understand these writs and precedents.
And here is the irony that I absolutely loved in the text. The king created this system to centralize his own power, right? But the bureaucracy became so technical, so deeply rooted in centuries of specific precedents and complex Latin writs, that the king himself couldn't just snap his fingers and dictate a verdict anymore.
Yes. The text points out that these legal professionals, who only existed because of the royal courts, later became the central force resisting royal absolutism.
That's amazing.
When a later king tried to simply impose his will or act above the law, the lawyers effectively locked him out of his own system. They'd say, "Sorry, Your Majesty, but the precedent of the writs requires a different outcome."
They protected the organic common law, even from the monarchs who birthed it.
They really did.
Which brings us to the deepest philosophical layer of this whole text, because they weren't just arguing over paperwork. They had a fundamentally different view of what the law actually was.
Yes, if we connect the mechanics of the traveling judges and the juries to the bigger picture, it reveals a profoundly different legal philosophy: the primacy of the judicial process.
Explain the difference between discovering law and manufacturing it, because I think this is the biggest aha moment of the entire deep dive.
It's a huge distinction.
Today, we think of laws as things politicians manufacture, right? A problem happens, a legislature sits in a room, they argue, and they literally make up a new rule. They manufacture a statute.
Right. But the common law judges did not view adjudication as the mechanical application of written rules. They didn't see themselves as creating law.
Okay.
They viewed their work as a continual process of discovering principles of justice.
Like a physicist discovering a law of nature. Gravity already exists. The physicist just observes reality to explain how it works.
That is exactly the mindset. The text explains that within the common law tradition, these principles of justice were understood as concrete expressions of divine law or natural law.
So it's bigger than them.
Much bigger. Truth and fairness exist independently of the ruler. The law is already out there in the fabric of the universe. The judge's job, aided by the jury's observation of the facts, is just to uncover it.
And the distinction between discovering and manufacturing is massive for the stability of a society.
Oh, absolutely.
The text points out that if a king or a parliament manufactures a statutory law purely out of human will, that law is fragile. It can be amended tomorrow. It can be repealed if a new king takes over.
But if a basic principle of justice is discovered through decades of practice, tested by juries and refined by generations of judges, it is seen as an expression of natural law.
It has weight.
Exactly. Its authority stands far above any temporary statute enacted by a human politician.
It makes the legal tradition incredibly resilient. You can't just repeal gravity, and you can't just repeal an enduring principle of fairness that has been proven to work across 100 different counties.
It shifts the ultimate authority from the arbitrary will of the ruler to the accumulated wisdom of the process.
So we've gone from broadswords and boiling water to the highest concepts of natural law. What does this all mean for us today?
Well, looking at Young Kang's text, there are really three massive takeaways from the success of the itinerant courts.
Let's hear them.
First, they achieved unity through practical competition, not through a forced monopoly. Second, they generated a stable system of rules through localized practice and feedback, not through abstract, top-down design. And third, they sustained order by discovering inherent principles of justice, rather than just manufacturing arbitrary statutes.
Those three pillars didn't just build a court system. They formed the foundation that ultimately supported the constitutional civilization of England, and by extension, many modern democracies.
They absolutely did.
And for you listening, whether you are designing a community framework, building a corporate culture, or managing complex logistics, the lesson is clear. Forced compliance is brittle.
Very brittle.
When you want to build something enduring, don't just dictate the rules from the top. Provide a genuinely superior option. Allow for feedback loops, let practical competition play out, and just trust the process of discovery.
But, this raises a fascinating, perhaps slightly dangerous question when we look at how our modern world operates today.
I love a dangerous question. Let's hear it.
So, if the English common law system achieved its legendary fairness, its stability, and its brilliance precisely by allowing multiple courts to openly compete for litigants,
Yeah.
What would happen if we applied that same concept of institutional competition to our highly monopolized modern public services?
Oh, wow.
Think about it. Today, we are locked into singular, top-down administrative bureaucracies. But what if citizens could literally shop for their civic administration the exact same way a medieval peasant shopped for a court?
That is wild.
If you could choose the most efficient, neutral, and rational provider for your public services and leave the failing ones behind, would that force a renaissance in how modern government operates?
That is an incredible thought to leave on. The idea of ending civic monopolies and forcing governments to actually compete for our participation.
It's definitely something to chew on.
We started with the chaos of the Dark Ages and ended with a radical blueprint for the future of government. Thanks for taking this deep dive with us today. Until next time.